2026. Welcome to the 2025-2026 New Hampshire Tech Alliance HR Exchange. My name is Jim Reedy. We're coming to you from She and Finney, host of the Tech Exchange, and I'm thrilled to be kicking off this year with an important topic, the ABCs of reasonable accommodation with my colleague Karen Whitley. Before we get started, just a couple of quick housekeeping items to mention. As always, this is a virtual presentation, which means that it's coming to you virtually, but also in addition to that, this is eligible for HR credits. Participants will receive, and I think I'm looking here now, we've got 170 people online right now, and I think as many as almost 400 registered for today, which is terrific. After the presentation, all participants will receive a copy of the presentation along with the HR credits. Next month, October 8th, Liz Bailey, our colleague Liz Bailey, is going to be talking about tips on conducting internal investigations, something that HR professionals do quite a bit, or have others assist them with that process. And Liz has an enormous amount of experience in that regard. We will continue on throughout the course of the year. I think the only month that we do not have one of these scheduled is the month of May, which is our annual employment law seminar. And I think it is November. Our November event will actually be in person, like we did pre-COVID, but more on that later as we send out the schedule. We've sent it out on LaborNet. We'll be sending it out again, and you can register for all of these on our website, shein.com. Well, truly, without any further ado, our important topic of today, the ABCs of reasonable accommodation. Karen Whitley is a partner in we have many offices, and she splits her time between our New Hampshire, and our Boston offices, and has a great deal of experience assisting employers with all manner of matters. But this is a hot topic for just about any HR professional dealing with the question of what is a reasonable accommodation. So turning it over to you, Karen.
Thank you, Jim. Good morning, everybody. So we'll be talking about the ABCs of reasonable accommodation. And although when you think of ABCs, you often think of, you start off with the building blocks and then go to the grand finale. I'm going to flip this a little bit and start with a case study. And so we'll get to that in a minute. And then we'll go through key laws that discuss reasonable accommodation, and there are federal and state laws in that regard. So we'll go through just the basics of each of the three that I've mentioned here. And I'll provide a list of resources which I think any HR professional would be well advised to just have available to them. Go through the interactive process. Spend some time talking about mental health conditions, because that is an area certainly where we're seeing increasing numbers of employees seeking accommodations for those types of matters. Briefly talk about interaction with other laws, state and federal. Give you a couple of statistics and end with some best practices. So we'll have you out of here in the next before 90 minutes, but there's a lot to get to, so let's just jump on in. As I mentioned, I'm going to start with a case study, and this comes out of the First Circuit Court of Appeals in July of 2025. So the First Circuit is the court that covers federal courts in New England, so New Hampshire, Massachusetts. This happened to have been a Massachusetts case, but wound its way up to the First Circuit Court of Appeals, and so the decision is binding on what happens in New Hampshire as well from the federal ADA perspective. So the case involved Dr. Lisa Menninger, who was the executive director for laboratory operations for a company called PPD Development. And her claim that she brought with the District of Massachusetts Federal Court and ultimately appealed to the First Circuit was that her employer did not provide her a reasonable accommodation and discriminated and retaliated against her because of social anxiety disorder. And she claimed a violation of both the Federal Americans with Disabilities Act and state law. The jury awarded damages against the employer, and when it was appealed, the First Circuit upheld that award. So, what happened? In 2017, the PPD employer was having some financial issues and decided it really needed to buckle down on its interaction with its clients. So it wanted to improve and expand its client relationships. So it was requiring the plaintiff, Dr. Menninger, to increase her contacts with clients. And she said when she found out that this is something that was going to be expected of her, that public presentations in front of large crowds made her anxious. And she then got some medical documentation confirming that she had generalized anxiety disorder, social anxiety, panic attacks, and that she was treating with medication as needed. Her first communication was that increasing client visits and social interactions would be difficult. So she did ultimately submit a written accommodation request that said she could tolerate public speaking if needed for her job, but increasing the amount of public speaking and client contact and social interactions, networking and that sort of thing, would worsen her symptoms. So, with her healthcare provider's assistant, she requested some accommodations. She asked to minimize social interaction or public speaking. She asked that her role not be changed to require more public speaking. And she asked for cooperation and collaboration to develop a plan for any necessary public speaking so that it would minimize her anxiety. So that could have been any number of things, just to communicate between the employee and the employer that there would be a plan in place for public speaking. So Human Resources response was to give her a list of tasks that she would be required to perform. And that did include some new public speaking requirements. So she went to her doctor and got a second request for accommodations, including asking for a surrogate or reader. So that person would attend client meetings on her behalf or in her place and make presentations. So she might go to the meeting and maybe do some of the networking or providing of information, but there would be somebody else there to step in if she had some sort of anxiety attack, or just to take over the presentation from the get-go. She said, I can certainly help behind the scenes. I can add value in a number of different ways. The company refused most of the accommodations that she was asking for, but they wouldn't say why, and they wouldn't give her the details of what she was actually going to be expected to do with this increased public speaking. And then the company started internal discussions to, quote, delicately work her out of her job. So there were emails and other memos that talked about this plan. And then they presented her with a choice. Either you transition to a temporary consulting role or you take an exit package. They started documenting criticisms of her performance when she didn't choose either of those other options, and they changed her performance goals. And then when she complained that she was being retaliated against, there was an investigation that was done, and there was a finding of no wrongdoing. The tensions continued given all these things that were happening, and that triggered a major depressive episode for this employee and caused her to take a leave of absence. When she used up her available leave, she was fired. And then she sued. And she claimed, as I said at the beginning, that they had failed to reasonably accommodate her, and then they had retaliated against her for seeking an accommodation. At trial, the witnesses for the employer had vague and inconsistent testimony. And ultimately, the jury found in plaintiff's favor, not failure, the plaintiff's favor. So, with all of those facts, you might agree that this feels wrong. that something happened during this back and forth that feels wrong. But how wrong was it? The jury actually found the employer liable for failure to provide a reasonable accommodation, discrimination, retaliation to the tune of $24 million. And that was comprised of back pay and $5.5 million in front pay, meaning that from the time that the judgment was issued forward, there was an award of $5.5 million, 5 million in past emotional distress damages, and 2 million in future emotional distress damages, and $10 million in punitive damages. If we were in person, I expect I would have heard a couple of gasps at that number. On appeal, because the employer did appeal the $24 million jury verdict, the Court of Appeals said that the ADA is a clear mandate to eliminate discrimination, and it seeks to dismantle the barriers that keep qualified people with disabilities from participating in work life. And ultimately, the employer will be found to have discriminated against a disabled employee when it refuses to make a reasonable accommodation for the employee's disability if the employer knows about the disability and the accommodation, and the accommodation would not pose an undue hardship on its business. So that is the lens that the appeals court was looking at this. Did the employer refuse to make a reasonable accommodation, and would there have been an undue hardship? That is what the jury was asked to do. On appeal, there were a couple of technical issues in terms of what had the lawyers done and what had the judge done at the trial court level. The First Circuit, in addition to those technical issues, was really focused on the punitive damages aspect of the decision, the $10 million. And under the ADA, punitive damages are allowed if an employer engages in a discriminatory practice with malice or reckless indifference to the employee's protected rights. So looking at what had happened during the 2017-2018 timeframe with this employee, the appeals court said the employer certainly could have said, we are going to change your job, right? We're going to add these public speaking requirements before knowing of her disability. And the employer was entitled to deny some of those requested accommodations initially. But something changed midway through that process. And the appeals court said that a jury could find reasonably that the employer acted with malice or with reckless indifference to the employee's rights because they pressured her to quit. And they did that before the interactive dialogue about her accommodations was completed. They invented false grounds to terminate her when they were writing her up for her performance issues. They set her up to fail with new goals. And one of the goals was to eliminate all laboratory errors. So, that's an impossible goal for most people. They conducted a sham investigation. In fact, and I mentioned earlier, the finding, there was an investigation. She did complain, an investigation happened, and it was found to be no wrongdoing. But the other issue was that one of the people who was accused to have been acting against her was the person who did the investigation. So stay tuned for Liz Bailey's presentation next month as to why that could be a problem. And the witnesses at trial were contradictory. And in fact, the HR person and a couple of other folks did suggest in their testimony that they knew that they couldn't fire her for her inability to do the job, which is why they engaged in this, quote, campaign, which is a very loaded term used by the appeals court, a campaign to manufacture termination grounds or pressure her to quit. And then they tried to cover up those efforts by saying it was performance related. So for all of those reasons, the punitive damages award of $10 million was upheld by the First Circuit Court of Appeals. The court did note that there are certainly cases out there where an employer might make a mistake during a reasonable accommodation process, right? They could misjudge the request. You could look at see somebody asking for a reader or a surrogate to basically do their job for them. And an employer might say, I have a problem with that. And that might be a reasonable difference of opinion. But in a case where it's really a matter of just misjudging, misunderstanding, that is a different case from then engaging in a campaign to manufacture a grounds for termination of somebody. There are also cases, certainly, where an employer might be viewed as insensitive, but that doesn't give rise to punitive damages. Really, it was the unique circumstances of this case. Disabilities may prevent an employee from completing essential functions. And in a case like that, even if somebody has an accommodation and they're unable to do the job, certainly a court can say that we're not going to agree to those accommodations. So in cases like that, and there are kind of shades of how wrong the employer acted, it is probable that there won't be punitive damages assessed. But the best way to avoid punitive damages and possibly the underlying liability that the company faced here is if it demonstrates good faith efforts to identify and make a reasonable accommodation. So I see one wow, right? In the comment and the Q&A, right? $24 million is pretty significant. And it comes down to a lack of good faith efforts in this case to identify and make a reasonable accommodation, because behind the scenes they were engaged in a real effort to oust this person solely because of her inability to do the job due to the social anxiety and other anxiety issues. So the takeaways from this case is that it is really important to take the duty to provide reasonable accommodation very seriously. It is going to be critical that employers be able to establish that they acted in good faith, that they engaged in this process that we'll talk about this morning in good faith, and that all managers and supervisors are trained in this area. I think one of the troubling parts of the Menninger case was the involvement of HR, and I think even in-house counsel in this scheme. And so it's going to be very important that HR certainly is doing its best to make sure all managers and supervisors fully understand what the ramifications are of doing this wrong. So, as I mentioned, let's now go back a couple of steps and look at what key laws there are that require reasonable accommodation. The first, the one that I'll spend the most time on this morning, is the Americans with Disabilities Act. That was amended in 2008, but it's been around since 1990, took effect in 1992, been around for a very long time. The Pregnant Workers Fairness Act also requires a reasonable accommodation and is fairly new, just about 2 years old. There's also state law, and New Hampshire does have a requirement for reasonable accommodation for known disabilities. And then Title VII, which is the source of the reasonable accommodation requirement for individuals who have sincerely held religious beliefs. So let's go through each of those. The ADA, it applies to employers with 15 or more employees. It prohibits discrimination on the basis of disability, also on the basis of a history of disability or perceived disability. And key to our conversation this morning, it requires employers to provide a reasonable accommodation to a qualified employee or job applicant with a disability to allow them to perform the essential functions of the job, unless there's an undue hardship or a direct threat. We'll go through each of those. So, as I mentioned, it requires the reasonable accommodation. And what is a reasonable accommodation? In the application process, it's a modification to that process. If somebody is applying for a job and needs, some sort of either reader so that the job application can be read and understood and completed by somebody who is visually impaired, something along those lines. So modification to the job application process. or an adjustment to the work environment or a change in the way that things are customarily done. And that's the change in the way things are customarily done or where things are customarily done, where those job tasks. That's really, I think, a really critical area where we see most of the accommodation requests. Or other change that enables an individual with a disability to enjoy equal employment opportunity. So there might be physical barriers. If you have, an employee on the sixth floor and there's no elevator and they're 8.5 months pregnant, or they have some sort of other physical disability that really makes it difficult for them to go up and down those stairs. Maybe is there an office on the first floor? So physical barriers, or procedures and rules, things, if they have to be in at 7:45 every day, but they have a disability that makes it difficult for them to get going in the morning. Are there rules, work rules, scheduling that can be changed? So reasonable accommodations do have to be offered to the qualified applicant or qualified employee, somebody who can do the core functions of that job, if they have a disability with or without an accommodation. And that requirement is regardless of the employment status of that employee. For example, part-time, full-time, or probationary introductory employee. So you can't wait for somebody to pass their 3-month introductory period before you provide them the reasonable accommodation if it is reasonable, and we go through all the process that we're going to talk about this morning. So some examples of reasonable accommodations, as I mentioned, maybe changing the arrival time, or maybe providing some additional breaks, providing modified schedules, whether it's a part-time schedule for a period of time or a shift change, modifying workplace policies, which can take, run the gamut. Anything in your handbook that somebody feels they cannot do because of a physical or mental disability or handicap, under state law, under Massachusetts state law, there are a variety of tweaks that might be able to be made to those policies as a reasonable accommodation. Reassignment to a vacant position. We'll talk about that in a bit. Assistive equipment and devices. I don't represent individuals very much, but when I was first starting out, one of the cases that I handled was for an individual who worked a switchboard at a hospital, and they just had to know where the numbers 1 through 0 were on the keyboard in order to do their job. But as time went on, they were having more and more difficulty because they were visually impaired, seeing that switchboard, the keys, and all they needed was some device to make those images larger. And the individual was fired, even though all he needed was a screen to magnify what he was looking at. So that did not go well for the employer in that case, because there was an easy assistive device that could have been put in place. Interpretive services, maybe somebody who is hearing impaired might need some additional help in that regard. Removing non-essential functions from their work list. Telework and leave is also can be a reasonable accommodation, or extending a leave. Now, the obligation is to provide a reasonable accommodation unless it would cause undue hardship. That means that it is going to be unduly costly, substantially disruptive, or fundamentally alter the nature of the business. In making an undue hardship defense, it's going to be important to consider the cost of the proposed accommodation, looking at that in the perspective of the size of the organization, the financial resources of that organization, and the structure and nature of operations. So somebody who is a pilot flying an airplane, if they, need to, lie down for a period of time, that might be difficult to impose or to implement because of the structure of the operations or the nature of where they are when they're doing their job. But looking at all of those factors and understanding that the undue hardship defense is a fairly rigorous element to meet. So it is possible to avoid providing a reasonable accommodation if you can meet those criteria, but understand that if that is the path that the employer chooses, their financial resources and other information like that will become part of the conversation or certainly part of the litigation. Another area that really became to the forefront during COVID was whether providing a reasonable accommodation would pose a direct threat. So we saw a lot more claims like that during COVID, where people were saying, I am not able to get a vaccine. I can't wear the mask, and I want to still go to work unmasked, unvaccinated. And so there were many conversations about whether that would pose a direct threat. Because under the ADA, an individual may not pose a direct threat to their own health or the safety, health or safety, or that of others in doing their job because of their disability or the accommodation that is proposed. So there must be, in order to show a direct threat, a significant risk of substantial harm. And that is not just a slightly increased risk, and it is not a speculative risk. It really does need to be imminent and substantial. And it has to be based on objective, factual evidence. So, for example, if there's a nurse who has Parkinson's and that nurse is responsible for drawing blood and their hands are shaking, then there may be objective, factual evidence that that nurse is going to miss the vein and cause injury to the patient. So it is not that potentially would be a direct threat, particularly if there's a medical documentation. Um, and conversation that can happen about what is the issue, what is the limitation that that nurse is experiencing, and what is the harm that is expected to any patient they come into contact with a needle. The direct threat analysis also has to consider whether the risk can be eliminated or reduced to an acceptable level. So it doesn't necessarily mean that the risk is completely gone. So, for example, with that nurse that has tremors, perhaps they are not doing blood draws anymore. There are other things they might be able to do, or maybe they can do a blood draw if there is some way that their hand can be steadied with some sort of a device that their hand can be steadied. So it's looking to reduce the risk to an acceptable level, not necessarily eliminating it. But this is all, again, an opportunity for employers to look and see whether there is a direct threat and decide whether there should be a reasonable accommodation provided. The Pregnant Workers Fairness Act took effect in June of 2023. There were regulations issued in 2024, and that law covers employers who have 15 or more employees, like the ADA. And those employers must provide a reasonable accommodation to a qualified employee or applicant with a known limitation that is related to, affected by, or arising out of pregnancy, childbirth, or related medical conditions, unless the accommodation will cause an undue hardship. The law, the PWFA, and its regulations are controversial, in part because the term related medical conditions is not defined and may include abortion and other issues, and that is the subject of litigation in several states, or involving several states. So currently, we do have that law in effect in most states, and here in New Hampshire, certainly it is something that employers need to make sure that they're complying with and are informed about what that law includes. And that in the reasonable accommodation area for pregnancy and childbirth and related medical conditions. The Pregnant Workers Fairness Act has in its regulations the examples that are provided that are reasonable for somebody who is temporarily disabled due to pregnancy related issues include a variety of things. I'm not going to read them all to you, but basically it's a lot of physical changes, maybe schedule changes, um, and importantly, I think for employers to understand that there is support for an employee to say, I can't do that one essential function, but it's for a temporary period of time. So temporarily suspending one or more essential functions could be considered to be reasonable under this law. Acquiring or modifying equipment and uniforms, that is probably much more easily done. So this is a wide range of accommodations that's suggested. But again, if there's something that is being requested as a reasonable accommodation and there's an undue hardship, it's the same analysis as under the ADA. But in addition, because of the fact that in many cases, the nature of the disability is temporary, um, of course, there are some pregnancy related conditions that will go on for much longer, for example, postpartum depression. But because of the temporary nature of the disability that's covered under this law, the employer should also consider when figuring out if there's an undue hardship, how long is the employee going to be unable to do those essential functions? And is there other work that the employee can do in the meantime? What essential functions does this employee do? And if there's one that's causing a problem or some that are causing a problem, how frequently do they do those tasks? Can other employees, maybe temporary employees, be hired or assigned to do those particular essential functions? Can those essential functions be postponed until such time as the employee is able to do that? And what do you do for other employees? So there's a whole other range of considerations because of the presumably temporary nature of the accommodation. And some accommodations are going to be always considered to be reasonable and not cause an undue hardship. I will say virtually always. And that is the ability of a pregnant employee to carry or keep water or food nearby, additional restroom breaks, time for sitting and standing, and time to take breaks and eat. Uh, Under the ADA, the reasonable accommodation process, we'll talk about documentation a little bit, but in under the Pregnant Worker Fairness Act, there are some limits on that because of the type of things. For example, the accommodations that are virtually always reasonable, it's going to be really difficult and not advisable for an employer to ask for documentation to support a request for those types of accommodations. But in any event, under the PWFA and its regulations, an employer should just ask for the minimum documentation to know if there's a physical or mental condition at issue. Is it causing limitations that are related to the pregnancy, childbirth, or pregnancy related conditions? And what limitation is needed? I'm sorry, what accommodation is needed to basically overcome that limitation and allow the employee to do the essential functions. So in some situations, it's just not going to be reasonable to ask for documentation, but if an employer does, asking for the minimum amount of documentation or focused specifically on the issue, that particular limitation. I'm not going to deal with state laws at this point. I know that we have many multi-employer, uh, multi-state employers viewing this. So I'm just going to spend a little bit of time on Title VII religious accommodations. Employers must reasonably accommodate an employee's sincerely held religious beliefs or practices unless it would cause an undue hardship. And there was a change about a year and a half ago where it had been the case that it was easier for an employer to show that a religious accommodation would be an undue hardship. But about a year and a half ago, a Supreme Court case changed that and said that to deny a religious accommodation, the employer must show that doing so would result in a substantial increased costs in relation to the conduct of the employer's business. So previously, if an employee asked for a religious accommodation due to a sincerely held religious belief, and the employer was able to show that it would cause a lower level of hardship for the employer to put that in place, the employer could deny the accommodation. But now, under this case, there is a higher standard for the employer to meet to show a substantial difficulty. So some examples of religious accommodations could be, again, flexible scheduling, swapping shifts. So if somebody needs Friday afternoon or Sunday morning off, for example, Friday, Saturday evenings, and there's some swap that can be made, allowing those to be done voluntarily, reassigning somebody to a job that they're qualified for that is open, and modifying other workplace policies. So those are just some examples. And I don't mean to give this short shrift, but we do have a lot to go over, and religious accommodations are certainly covered by some of the 150 guidance and technical assistance publications on the EEOC website. So there are a bunch. And I just plugged in eeoc.gov and reasonable accommodation. It came up with over 150 hits. So you will find that there's very consistent themes that run through a lot of these. So you don't certainly need to read all of them, but there is an effort to identify specific areas of interest and provide guidance on that. So there's a general enforcement guidance on reasonable accommodation and undue hardship, but also guidances for small employers, for contingent workers placed by temporary agencies and staffing firms, for healthcare workers. Then there's also a number of guidances that speak directly to the individual with a disability. Uh, as I mentioned, there's religious accommodation guidance, religious garb and grooming guidance. So you will probably find something that is helpful to your particular situation, at least to give you a starting point and the basics of what the specific law requires. So I encourage people to look at this when you have some free time, and just to figure out if there's a particular guidance that will be your go-to. So the bottom line here is that employers need to provide a reasonable accommodation. We saw the consequences of not doing that earlier in the presentation, but how do you do that? How do you identify a reasonable accommodation? And the key here is the interactive process. So where does that interactive process come from? The Americans with Disabilities Act regulations said that to determine the appropriate reasonable accommodation, it may be necessary for the covered entity to initiate an informal interactive process with the individual. And this process should identify what the limitations are, the precise limitations resulting from the disability, and the potential reasonable accommodations that could overcome those limitations. So it says may be necessary, but I think we've seen that if it is necessary and you haven't done it, there's going to be a problem. So what is this interactive process? As you can see from the regulation, it's something that's initiated by the employer, but it's a two-way communication. And it helps the employer and the employee or applicant identify what is the limitation due to health, pregnancy, or sincerely held religious belief. What is the adjustment or change at work that's needed due to the limitation? And what are potential reasonable accommodations? So that there is a change that's needed, and here are some suggestions. It is important to recognize there is not a checklist or a rigid steps that you need to go through in the interactive process. The key is for each specific situation, communicating, getting information, and figuring out what can be done, either to provide the reasonable accommodation that the employee requests or an alternative one that will help them do the essential functions of their job. So, as we've seen, the failure to engage in an interactive process can lead to liability for failure to provide a reasonable accommodation. But is this required in every situation? It's not. I would say it is rare not to do it, not to have to do it, and it is rare not to want to do it. But there are some situations. For example, if the accommodation is readily obvious and agreed upon, it will either be quick or it won't really even be considered to be an interactive process. The employee says, I'm pregnant and I need to carry a larger water bottle with me." Um, that's okay, right? So there's really not an interactive process there. But on the other end of the spectrum, and this is again a rare situation, if there is indisputable evidence from a doctor that the employee is physically unable to perform the job with or without a reasonable accommodation, that maybe that back and forth, just here's my doctor's note, uh, here's what I need. No, maybe that's going to be enough, and that will be the end of the interactive process. But I will just say in the Jones versus Walgreen case, which goes back many years, it was an employee who was supposed to, manager, I think, who was supposed to stock shelves, but the doctor's note was you cannot bend, lift, sit, stand, lean, any of these physical issues. And that was part of her job. And so there was indisputable evidence in that case that the employee physically could not do the job. So a more of a back and forth was not required. But again, it should be the rare situation, I think, where you don't at least have some back and forth and careful consideration of what the employee is requesting if they present information from a medical provider about the limitations on their ability to do the job. So, what does an interactive process look like? As I said, it's important that every single situation be treated individually. Just because somebody asked for a specific accommodation and it was granted or denied in the past doesn't mean it will be granted or denied the same way in this particular situation that you're facing. But the other important factor is just because somebody who had a particular disability needed an accommodation, you should not assume that another employee with that same disability will need an accommodation at all. So it's important to take every situation individually. And typically, it is the employee who starts the conversation about, I'm having trouble doing X. There's no magic words, and it doesn't need to be in writing to start the reasonable accommodation process. But the employer can also start that discussion, and often that comes from we see you're having trouble doing X, or we see that you've been coming in late, every single day after being, not having any attendance issues at all for the past 5 years. Is something going on? So the employer can start the discussion, but do it carefully. Don't assume again that somebody needs an accommodation. Don't assume that they have a disability. It is open-ended questions. This is what we're seeing. What can we do to help, if anything? A doctor's note is not required to start the process. The employee can say, I'm having trouble doing this, or I just switched my medication, or there's, something going on with me and my doctors are trying to figure it out. You don't need a doctor's note to start. Ultimately, it's going to be a very good idea to get medical support before offering an accommodation so that you set a precedent with that employee and others that there's a process that you go through. But the doctor's note is not required at the outset. An employer should respond to requests promptly. And that is where training comes in of managers, so that managers and supervisors know to be listening for this employee needs some help. This is what they've said to me, and I now need to escalate this to HR. So in order that HR can respond promptly, they need to know what's going on. So encouraging encouraging supervisors and managers to react quickly and to not necessarily answer the employee right in that moment. No, I can't get you a stand-up desk, or, yes, you can, leave every single afternoon early so that you can go stretch your back. You don't want the managers or supervisors to be making the final decision promptly, but you certainly should have them involving HR very, very quickly so that HR can at least have that initial conversation and outline what the process is going to be with that employee sooner rather than later. An employer will get medical documentation or can get medical documentation and can ask, or in the case of a religious situation, could get documentation, although that is not as routine as getting a medical certification for a limitation. But an employer can ask for clarification if something comes across their desk, they can't read it, they don't understand it, or this is not what the employee is telling us. And in that case, we often recommend following up with a medical questionnaire, which is just a form that says, it goes through the employee to the healthcare provider saying, here is what we are seeing. This individual, has these are their job duties. Here are the deficiencies that we're seeing. Here are the problems that we're seeing. Here are the concerns that lead us to think that they are not able to do the essential functions of their job. And here are some questions that we have. Does this person have a medical condition, mental health or physical condition that could explain what we're seeing? And is there a limitation that comes along with that? And what are the accommodations that we might offer? When the employer gets those accommodation requests, understand that those are requests, those are suggestions, but the employer is not bound by that and can propose alternatives. And the employer can ask about the duration of how long a particular limitation might last and document the whole process. And we'll get into that in a second. So just an overview of the a reasonable accommodation and interactive process. Whose duty is it to suggest those accommodations? The employee should show the existence of a reasonable accommodation. In other words, make a suggestion. Here's what I'm having trouble doing, and here's what I think could help. That is critical because you don't want the employer to be imposing its view of how limited this employee actually is. The employee might say, I just need to sit down for 5 minutes every 3 hours. I'm standing, standing, standing. I just need a seat for 5 minutes every 3 hours. Whereas the employer might say, oh, you can no longer do this standing job. Let's move you out of it. You don't want to go, to that extent. So I would get the existence of what the employee thinks might be helpful upfront. If the employee doesn't raise a possible accommodation during an interactive process, it's likely going to be prohibited from saying anything about that if there's litigation. So it is helpful to have documentation that shows this is what the employee asked for and not rely on this is what a conversation was between HR and this employee. Make sure that it's documented. And if HR has a conversation and the employee says, I really don't need anything but this 5 minute break, make some sort of email or memo back to the employee confirming that that's what they said. And if this was a misunderstanding that you need more than that, let us know. But having that documented is going to be very, very important, so that the employee can't say, well, I said something different during the interactive process, or the employer could have done X, Y, or Z, but I never suggested it. But it's the burden or onus is not only on the employer, the employee. The employer should do its homework too. It is, and we'll get into what that homework can consist of in a couple of slides. So I do see somebody had posted a question about what do you do if an employee has not responded to providing a documentation? There is a case that, again, goes back several years, First Circuit case dealing with the uncooperative employee. And there are many other cases like this, but this one, was again appealed all the way to the Court of Appeals in Massachusetts. And in that case, but it covers New Hampshire. And in that case, the employee was upset. They were asked to work at Kohl's, and I think the individual had diabetes and was scheduled to work till closing one night and then opening the next morning. And that schedule was very debilitating for the control of diabetes. So the employee asked for an accommodation, but got very, very upset during a meeting about those accommodations with the manager and threw the keys down to the building, threw the keys down and stormed out and resigned. And the employer, not only did somebody try to follow them out of the employee out of the room to make sure they were okay, but followed up with her twice to discuss accommodations and got no response. So the employee had resigned. The employee was ignoring subsequent efforts to discuss accommodations. And I would say, in some cases, employers might say, okay, they resigned. I'm washing my hands of this. I don't have to do anything. But in this case, the employer actually followed up two separate times afterwards to try to start the conversation again. And in that case, the employee was responsible for the communication breakdown during that interactive process. So the employer had acted in good faith. They had attempted to figure out what would work for both parties as part of this reasonable accommodation process, and the employer was not liable for discrimination or failure to provide a reasonable accommodation. And the messaging really from this case is that this process requires two-way cooperation and communication. Both parties, the employer and the employee, have a duty to act in good faith. And so if that is the case and the employer has done what it can to obtain documentation from the employee, maybe give a short extension to get the medical documentation in, emphasize the importance of getting the healthcare provider on board or encouraging the employee to find a different healthcare provider in some sort of urgent care setting, even where they can get some documentation that will help the employer understand are the limitations and what might some reasonable accommodations be. Then the employer will not violate the ADA when there's a breakdown in this process. So reaching impasse is not where you want to be, but at least if the employer has done what it can to get to a point where it has exhausted what it can do and it has obtained the information of what the employee can do, that at least there's this good faith process backing up an impasse that will be helpful in defending a claim of failure to accommodate a disability. The other point is that an employer who refuses to agree to a specific accommodation that is requested is not necessarily acting in bad faith. So the employer can say, we just can't do that, and here is why. And if there is a discussion and supporting documentation, and if you can show that for other people who have asked for a similar accommodation, you've treated it the same way, you have acted consistently, and you've made a diligent attempt to provide other accommodations that could work, then failure to agree or refusal to agree to a specific accommodation is not necessarily going to be viewed as bad faith or not acting in good faith. Uh, I have two variations on here is my job, and this is what I need to do my job. The first is changing the job. So an employer should try to reasonably accommodate how the employee performs their job, the essential functions of their job. But it's important to recognize that some changes to a job could be appropriate. For example, if the employee has core essential tasks that they do, but they also do marginal non-essential tasks, those non-essential peripheral duties could be stripped away, leaving the employee with their core functions. You could potentially assign some of those non-essential functions to somebody else. But an employer is generally not required to eliminate essential job functions permanently. As we saw under the PWFA, maybe there is some temporary adjustment that needs to be made. But if an employer has decided and made a reasonable decision that there are essential functions that are fundamental, and that's what that employee was hired to do, that's what they get paid to do, those essential functions generally don't need to be stripped away. They generally, you can require that the employee do that with or without a reasonable accommodation. The employer has that discretion to decide what functions are essential, but understand that if there are some functions that the employer is saying are essential, make sure that you've done that consistently for others in that role. Has anybody else sort of done some informal accommodations? Does one of their buddies pick up that 50-pound box for them every time they need it? So is there consistency is important before you decide that you are going to stick to your guns and say, no, this is an essential, fundamental task that this employee needs to perform. Uh, the employer is not required to eliminate the essential functions generally, and is not required to allocate essential functions to other employees generally. The other area that you will see, I have really emphasized, do not overlook the option of finding a vacant position for which this employee is qualified. This is in caps because in the past year, I have been in the position of representing employers who maybe looked for a vacant position but didn't document it, or did not look for a vacant position and just looked at whether the employee could do their specific job. And in those cases, the EEOC has found probable cause to believe that discrimination may have occurred. So the finding of a vacant position or reassigning of a qualified employee or an employee to a position for which they are qualified, if that vacant position exists, understanding you don't have to create a new job, and you don't have to bring one back if there was some sort of restructuring and a job ended. But don't overlook the the question of, is there a vacant position that this employee could do? If we have an employee that does a certain thing and they need to work remotely, and their job cannot be done remotely, is there a different job that they could do remotely? Because the failure to explore vacant positions can have a very negative effect on the employer. Whether to agree to a requested accommodation, just some questions to keep in mind. What is the employee asking for, right? Is it reasonable? Is it doable? Will it help the employee perform all of the essential functions of their job? If it helps them perform only, 4 out of 5, well, what do we do about that fifth one, right? Is that something that could be offloaded to somebody else, or is it an essential function that this person really needs to do? Does it cause an undue hardship in the ADA context? And religious, under all three, ADA, Religious Accommodation, and Pregnant Workers Fairness Act? And does it cause a direct threat to safety? I don't believe there's that exclusion under the PWFA because of the nature of the disability. But in most cases, you could examine whether there's a direct threat to safety based on what the employer is being asked to change. Want to spend a couple of minutes talking about the interactive process itself. And how do you set yourself up for success when you're doing an interactive process? Before issues arise, I would strongly recommend reviewing and revising job descriptions to make sure that they're accurate and complete, and that you have thought about, if somebody comes to us and says they need to work remotely, or if somebody comes to us and says they need they can't lift over 20 pounds, or somebody, says, that I can't focus. Uh, is there enough in your job description to talk about those specific job requirements, and physical and mental job duties? Is it accurate and complete? Does your job description identify what the essential tasks are and perhaps identify some as non-essential, or at least say, here are the core responsibilities, but may also be requested to do X, Y, and Z. So is there some delineation in the job description that will be helpful if somebody comes and says, I can no longer do that task? And that task is clearly identified as a central core responsibility for that job. Involving employees and supervisors in the job description review is helpful to make sure that the employee in that job agrees that this is what they're supposed to be doing and understands the importance of that task to their role in the company. And then before anything arises, training. So the training should emphasize that HR is handling disability and accommodation issues, and that supervisors should and managers should refer those issues to HR. Medical information will be obtained during this process, and it should be isolated in HR in a separate file. Supervisors should not unilaterally grant or deny requests. That's not only so that you want to make sure you have consistent treatment of employees, but you also want to make sure you're not setting any precedent with a supervisor in this department saying yes to something and in a different department turning it down. So good, just some aspects of training that would be helpful to have in place before you have an issue. But then when issues arise involving the employee and their healthcare professional, to identify the limitations and the restrictions and identify possible accommodations. But that said, the employer should be, excuse me, researching and proposing accommodations as well. And I'll talk about that in a minute, but remaining flexible, open-minded, and understanding that, you may have one perception when you're talking to the employee, and then when you see what the medical documentation says, it's going to be important to be flexible. So when I'm saying that the employer should research and propose accommodations, there are a couple of places to look. So I referred you to the EEOC guidance at the beginning of the presentation. But I wanted to bring to your attention, if you're not familiar with this resource, it's the Job Accommodation Network, or JAN, askjan.org. And it's a free service, and it is a wealth of information. It has both technical assistance and training, and provides potential solutions. If an employee has X limitations, here are some possible solutions or suggestions. So, for example, if you were to search the JAN website, you could find a guidance on employees with executive functioning deficits. And that guidance, that publication, takes you through practical steps to help employees with all of these types of executive functioning issues. And so in the guidance, there's a breakdown of time management and what might some potential aids be, or paperwork and social skills, those types of things. So it just provides some guidance to employers and employees about what potential steps they could take, practical steps they could take, potential accommodations that they might incorporate into that employee's daily work. Conducting an effective interactive process could also include the ability to put interim accommodations in place. So obviously you're waiting for, you hear from the employee that there's an issue. You might be waiting for some medical documentation or other documentation to support what they need and what they're looking for, and that this proposed accommodation will help them perform their job. But in the meantime, is there something that can be done so that the employee is safe and productive and is still working and is perhaps not kind of racking up performance or attendance issues in the process? So perhaps there's an interim accommodation that you might put in place just temporarily while the process unfolds. And then continuing the discussion with the employee until you either have an impasse. No, we're not going to give you the specific accommodation that you are looking for, and there's really nothing else, no other positions. We can't take away the essential functions of your job, that impasse, or until you have an agreement reached. And understand that once an agreement is reached on what accommodation might be put in place, that might not be the end of the conversation, because it may be that that accommodation is appropriate for a while. But both the employer and the employee can revisit that if it looks like the accommodation is not helping the employee succeed, or it's not enough, or it's no longer necessary because the employee's disability has abated, or their temporary disability has abated in some way, or they've figured out something else that will work for them without the specific accommodation. So it is not necessarily a one and done. It could be an ongoing conversation that is raised by the employer or the employee. The importance of documentation can't be overstated. It is a really critical part of defending a claim, but an agency or a court, that an employee didn't ask for an accommodation, didn't ask for that accommodation, or that the employer did everything they could to try to get an accommodation in place for this employee that would be helpful. So it shows the employer's good faith efforts. It might show the employee's lack of good faith. It might it should show what the options that were suggested and what modifications the employer suggested, and should explain why the employer did not agree, if the employer did not agree to the specific requirements or requests of the employee. So an analysis of this can't be done because, again, that's not something that you would necessarily need to give the full analysis to the employee. Obviously, the more information you give to the employee, the more they are going to understand where you're coming from, and potentially that takes a little bit of the wind out of their sails if they're thinking about litigation. But there can be an investigation or a medical file that includes their medical documentation, but a file that is all about this interactive process that you are keeping potentially for litigation. So it would confirm also the alternative positions that were considered. Again, that is a critical piece of this, that if you take nothing else away, the word of warning is to be open-minded about trying to find something else, another position for that employee. I want to spend just a couple of minutes on mental health issues because of the frequency with which our clients are seeing these sorts of things. And I want to point out two guidances that were issued, a while ago, almost 10 years ago, but they're still helpful, by the EEOC. One is a Q&A guidance that was developed for employees, but it includes a couple of things, some questions about how can I get a reasonable accommodation? What happens after I ask? And what if there's no way I can do my regular job, even with an accommodation? So it's helpful for an employer to see these sorts of publications, to know what are the employees being told. And the other part of it is the sort of the companion publication that was put out at the same time, was the mental health provider's role in a client's request for reasonable accommodation at work. And that was helpful because a lot of times we'll be, as counsel for the employer, we're recommending that this questionnaire go to the healthcare provider to ask about, does this employee have work limitations, and what are the accommodations that might be needed, and how do you know that this will help? And so it's helpful to know, what does the mental health provider understand about this process? And this is a good guidance to understand what the mental health provider's role is. But there were a couple of good reminders that I wanted to call out for you. The first is that um, the employer has to provide the reasonable accommodation, obviously, but the employer is not required to provide an accommodation that is unreasonable on its face. It's not doable, or that would cause significant financial or operational difficulty. That's the undue hardship part. So this is language from the EEOC in its guidance about the mental health providers. And the employer is not required to excuse the employee's failure to meet production standards or rules of conduct. So if somebody is actually unable, they're in a call center, and they're actually unable to carry on a conversation or move people to the next step, in their call dispute for whatever reason because of a disability, if they cannot meet those production standards and they cannot meet their rules, your rules of conduct, even if that difficulty is caused by a health condition, you do not have to excuse that. Um, and you don't have to keep on a worker who cannot do the job even with a reasonable accommodation. So although those are very good reminders, understand you want to go through a lot of the interactive process before you make any determination about any of these things. But it is a good reminder that the EOC has acknowledged that you don't have to excuse the basically the blatant failure to meet rules of conduct. So somebody who has a disability of anger management and is causing havoc in your workplace is not meeting your rules of conduct. And that is not something that you have to abide by. You can still hold them accountable. For mental health resources in particular, there are a couple that I would, recommend, which are here. But I'll also say that employee assistance programs are obviously helpful, not just for mental health reasons, but for others. So if you have that resource available, it's a good recommendation to employees, and it also potentially takes HR out of a lot of the discussion. If the employee can be talking to their healthcare provider and getting help from an EAP, and then coming back to HR and saying, okay, this is what I need. A word about confidentiality. The reasonable accommodation process is going to, if done correctly, lead to the disclosure of at least medical information, but potentially personal and sensitive, information about that employee's abilities and limitations and what they need. Employers are required to keep medical information confidential and limit to the people who have a need to know. So that means, although I know supervisors play a role in helping you identify that an accommodation is necessary and helping you figure out whether a proposed accommodation is workable, that doesn't mean that the supervisor needs to know all the details. Now, the supervisor is probably going to be the recipient of some oversharing, maybe the recipient of oversharing by an employee. So they may know the details, but it is better to keep their involvement limited to, here are the limitations that we have seen. Here are the problems, deficiencies that we've seen with the employees' performance or conduct. And here is, a list of accommodations that we can put in place so that the employee isn't being required to share personal medical information beyond those who really need to know it. Interaction with FMLA and state leave laws. As you know, FMLA provides in the majority of cases up to 12 weeks, maybe up to 26 in certain circumstances, but up to 12 weeks of unpaid protected job leave for a serious health condition. And many states are developing state leave laws, which provide, more than that, to deal with serious health conditions. But at some point, somebody may exhaust those weeks of leave, whether they're paid or unpaid, and may need additional time. And it's important to recognize that the ADA leave may be a reasonable accommodation after the leaves have been exhausted. There is no bright line rule about how long a leave would be reasonable, and it is very fact specific. But I did want to point out that in the PWFA regulations, which are, only about a year old at this point, the EEOC did have a footnote that talked about what indefinite leave looks like, right? So that it is pretty clear under case law that you don't have to provide an indefinite leave. The problem is putting the parameters about what that means. And the EEOC has disagreed that 2 to 3 months of leave after a 12-week FMLA period was unreasonable, right? So at least presumptively unreasonable. So in one of its footnotes, where it was discussing a case where an employee had asked for 2 to 3 months of leave after being out for 12 weeks, the employer in that case said it was unreasonable to have to grant that additional time. And the EEOC said, you can't make that presumption. You have to go through more detailed analysis about whether it was actually unreasonable in that particular circumstance. So, unfortunately, the bad news is I'm not able to provide a bright line rule about how long people can take this additional leave after leave laws expire. But it will just be an analysis about the essential functions and what work is or is not getting done and how critical that person is. There's a lot of factors that will go into it, but indefinite leave, if somebody says, I don't know if I'm ever going to be able to come back, that's probably the easiest case of saying it is not definite, it is not reasonable for us to grant that additional leave. Just a couple of stats here. The EEOC has filed 33 lawsuits just in the fiscal year 2024 about a failure to accommodate. And most of those cases involved inflexible policies. So this is our rule. You have to do it. It doesn't matter if you have a disability that's preventing you from doing it. Or a requirement that an employee come back to work with no limitations. And so no accommodations will be provided. So that's, again, that inflexibility is going to cause problems for the employer. And then there's two COVID-19 vaccine cases just in the 2024 timeframe, but obviously those cases are ongoing. And there were more before and after the fiscal year 2024. The consequences for mishandling an accommodation request, the both the EEOC and state agencies, not only can they award damages as through their process, but they can also do civil money penalties. And then there's legal fees and litigation costs if a case is pulled to go to court. To kind of bookend with scary cases, there's another case from a year or so ago involving Wells Fargo, when an employee was in a really bad car accident and had a paralyzed colon and bladder, and he needed to go to the bathroom frequently. So this was during COVID. So he was able to work remotely for a long period of time, but then he was told he needed to come back to work, asked for the accommodation because he needed to be close to a bathroom, and instead he was included in a layoff. And in that case, he was awarded $22.1 million. That case is still being appealed. I think it's in Georgia. And it is, it is still actively under appeal, which just leads to the more legal fees. This case is not necessarily a reasonable accommodation case, but it is one that was involved the ADA, and it's the Supreme Court, U.S. Supreme Court in June of this year. So I just wanted to highlight some good news for an employer. In this case, a city had changed eligibility for insurance so that if the employee had retired due to a disability, they only got 24 months of coverage, as opposed to unlimited healthcare coverage after they retired. So this change happened after the plaintiff, who was a firefighter, had retired due to a disability. And the firefighter sued the city saying, you're discriminating against people who retired due to a disability. And the Supreme Court well, all the courts, District Court, the 11th Circuit Court of Appeals, and the Supreme Court dismissed that claim because the firefighter was not a qualified individual with a disability, meaning that person was not somebody who held or desired a job and could perform the essential functions with or without a reasonable accommodation, meaning they were no longer in the job, didn't want to be in the job, couldn't be in the job, and therefore they were not protected by this particular law. I'm going to close with some best practices. I see many questions in the Q&A, but I also see that most of them are hypotheticals um, that I think, are not not really able to be answered without knowing all of the background facts, unfortunately. But to close, hopefully, what I've said during this presentation will at least give you some touch points to think about those questions in a different way. But just to close with some best practices, I've mentioned training managers. Watching for situations where health impairments could be causing performance issues is really something that managers need to be attuned to. However, they should also be aware that they just can't assume that because somebody discloses, I have cancer, or I'm going through radiation, or I'm pregnant, or there's some other issue that they're dealing with, that doesn't necessarily mean that they need an accommodation. It really should be that they are limited in some way from doing their essential functions that starts this reasonable accommodation process. Training managers not to diagnose employees. Some say, oh, my, sister's nephew's wife had that, and this is what I now know about that disease or that disability. So avoid diagnosing employees and treat each particular situation on its own merits. But be alert to the subtle requests for accommodation. Somebody might not come and say, I need a reasonable accommodation, right? That's not required. But asking for help to do something, or informally reaching out to other people to help them do things might be their at least beginning of a cry for help. Referring issues to HR should be automatic for your supervisors and managers, and they should not put themselves in a position of addressing these types of things on their own. Not only does this limit the risk to supervisors, um, that they are taking, for example, a mental health disability into account later, right? If they can say, I don't know what was behind all this. I just know she was having trouble, so I sent her to HR. Whereas if the supervisor has a detailed conversation with somebody, that information now cannot be unlearned. And if a supervisor later takes a negative action against that employee could say, that's because we had that conversation in September about, my mental health issue. Be clear about objective job expectations and document when the employee does not meet them, right? That you can still do that even if they're in the process of a reasonable accommodation, but you want to do that very, very carefully and with good advice. Ultimately, the area that trips up managers, supervisors, and companies in general is retaliation, right? Not recognizing a reasonable accommodation and maybe mishandling that process. There's a lot of gray area there, but retaliation, it can be very, very clear if somebody asks for an accommodation and then they lose their job, or they ask for an accommodation and all of a sudden they're isolated, or their performance is criticized, etc. Avoid retaliation. And managers should work with HR, who should work potentially with other professionals just to figure out how do we best frame this to show that we are not retaliating, but we are trying to ensure that our job gets done. Ensuring consistent treatment of employees is obviously a really big part of that. Okay. Treating each situation independently. I've said this before, and involving healthcare providers for reasonable accommodation suggestions is going to really set employers up for success because then they're not assuming they are acting on, and they're not acting as the doctor, right? They're not medical professionals. They are not acting as that. They are relying on a professional to provide information about what this employee's limitation is and what reasonable accommodation suggestions they have. It goes without saying, acting promptly and in good faith can help avoid some of the, mind-blowing damage awards that we've seen this morning. But one of the things that I would just emphasize is asking HR to ask themselves and to ask supervisors, is there a way to save this person's job? We often get calls well after, this has gone to, to a point where nobody wants to be working with anybody, the other person anymore. Ask that question early. What can we do to save this person's job? And use the resources that are available, EEOC, Jan, and council. Documenting performance issues is sort of my final point to you because of the importance in defending yourself in any sort of claim. I see there are questions. I definitely want to get to this. I'm sorry that I did this at the literally the last second. But I will certainly look. And if I think most of the questions are anonymous, so I'm not sure I'm going to be able to address them anyway. But if there's something that pops up in the Q&A and it has been identified, I will certainly shoot out an email. But again, thank you for your attention this morning, and I hope you all have a wonderful day.